to David Pearson, who is a member of the CCCBA Board of Directors and the moderator for this panel discussion. David?
Thank you, Anne. As Anne said, I'm David Pearson, and I just wanted to let you know I am actually here to field all of the questions for our panel. I am not necessarily a speaker today. So for all of those who are watching, if you have any questions that you would like the panel to address, just send them to me or post them in general on the chat window or in Q&A, and I will get those questions over for our panel to answer. So thank you for attending, and with that, I will turn it over to the panel and Judge Fannin.
So we're all going to introduce ourselves. I'm Judge Fannin, and I've been in this civil assignment since 2019, I think, and I did it 2 years before, a number of years ago. I've been a judge since 2003, and there you have it. Phil Andersen, I'll go to you now.
Thank you. Can you hear me okay? Thank you for allowing me to be here today. I'm Phil Andersen. I'm the managing attorney of the State Farm Legal Office in Pleasanton. We handle the Bay Area counties. We have about 800 or 900 cases pending at any given time. So there's a lot of litigation going on. I find it great to be here with Larry and Robin. They were both on the panel that interviewed me to be part of the board for Contra Costa County Bar Association. And 8 years later, I became the president following Larry. And of course, Robin was also past president. So glad to be here.
Let's go to Larry.
Well, good afternoon. I'm glad to be here as well. I'm Larry Cook. I'm a partner here at Casper, Meadows, Schwartz, and Cook for many years. We're plaintiffs, personal injury trial lawyers, and happy to say I don't carry near the caseload that Phil Andersen does.
Robin.
And I'm Robin Pearson. I am a partner at Roper's Majeski in the Walnut Creek office. My practice is real estate, business, and commercial litigation. And I am a past president of the Bar Association. As Phil mentioned, I was president in 2008.
So, and I should have said I'm happy to be here too. I really am. And I look forward to your questions. We're gonna just generally go around and talk in 3 big groups because there's too much to talk about. So 3 big segments. The first is going to be general Zoom/COVID, our impressions on how that all went. Then we're going to go into discovery, and then we'll go into mediation/settlement conferences. And as we do a roundtable here, would be interested if the attorneys could sprinkle in whether they want it to stay, keep doing what we're doing, or don't, or what their thoughts are on that as we go. So first of all, going with how generally with Civility people thought Zoom and the COVID protocols worked, and I'll start with Robin.
Thank you, Judge Fannin. I think overall, for at least my practice, I have found that Zoom has been very helpful, actually. I really appreciate being able to tune into Zoom without having to deal with traffic and drive to the court very early in the morning. The further away you live, that becomes quite an obstacle. So that has been a real pleasure for me. As far as other areas of Zoom, it can be challenging. And I know we'll get into that a little bit more when we get into discovery issues and law and motion issues and things of that nature. But overall, my experience has been positive. There are some effects in dealing with Zoom and being on Zoom calls constantly. I seem to average in a week about 3 to 5 Zoom calls a day. And these usually aren't very short calls, and that does take its toll on you. I have found that I have suffered some effects like headaches and fatigue, more fatigue than I usually experience after a long day of Zoom calls. I'm just completely wiped out, and that normally wasn't the case. And I do miss physical interaction with people and being able to look at them directly and talk with them face to face. But overall, I would say it's been a pretty positive experience.
Phil, what about you?
So a quick story to start. At the peak of the COVID in December, I had my daughter-in-law living with us and my father-in-law, who's 90. My daughter-in-law got COVID. We're all in the same house, and I was so worried that he was going to die. I have lung problems, and I was afraid I was going to die. I think COVID has had a profound impact on our feelings about life and death and goodness and helping. And I hope that I've seen a change in the way people behave. I've taken over 60 depositions by Zoom during COVID. I've gotten calls the night before saying, I got COVID, I can't do the depo. Everybody seems to be more supportive. I remember when we used to have to order a video deposition when we had a really difficult plaintiff's attorney that we knew was going to act up, because we knew that by videotaping, he would or she would be under control. This is what's happened, I think. We see ourselves all the time. We're looking at ourselves. And when we act inappropriately, it's hard to hide it. And so I believe that the civility has increased and gotten better because of it, because we're more sympathetic, we're more caring, and we see each other when we're talking. So I think it's gotten better, and I hope it will continue.
Larry?
I agree with what Phil has said, and I just on the greater COVID issue, I think that it has caused us as lawyers to understand that we're human beings first, and you have to be a little more careful when you're insisting on deadlines and not being cooperative, because you just don't know what's going on in another person's life. I mean, I've had cases where lawyers in big firms have dropped off the case. It's been handed to someone else. Been told that the lawyer has left the firm. I'm very concerned, where I never would have thought about that before. And I see that in the conduct of opposing counsel and co-counsel. I think overall, we have a better sense that we are all human beings and we need to treat each other. And of course, the rules of ethics and professional conduct require that, right? And our court has rules about it. And for those who practice in the federal court, certainly there are clearly articulated rules about how to be ethical. And I just think that because of, the lockdown and the impact on people generally, that we've become more in tune to that and more respectful. That's what I've seen. And I'm certainly hoping that carries forward. So that part of it is a positive. I think the Zoom generally has been great. I've been around a while, and so I'm glad that I'm able to learn and cope with the technology. Maybe others feel that way too. It's opened things up. Not to mention agreeing with the things that Robin said about just the practicalities, not having to be in a court in San Francisco at 9 o'clock in the morning from Contra Costa, not having to, travel and fight traffic and park and all the anxiety and stress that goes along with that, I think is a big positive. And not to mention the financial costs, the savings and the environmental savings that have gone along with it. So I do miss being in the courthouse, Judge Fannin, I really do. I miss the interaction with people. That's kind of been my thing my whole career. But the trade-offs, I think there are some very good things that we should carry forward as we try to get back to normal.
So I have experienced the goodwill among counsel in general case management conferences and in settlement conferences and all that. And I would say overall, my impression is that during COVID, parties have been more cooperative, more understanding. And so that's been great. And I would say that personally, I have loved doing things on court call because it's quick, and I know we can't keep doing that forever, and we're going to have people back in, and I do like having people come in, but it's easier when it's one media, so it's always more complicated if I have someone on court call and someone in the courtroom, or so it's just been nice having it all on one. But and Zoom, I have really enjoyed Zoom, and I feel like people are more relaxed on Zoom than in the court, and so I think that has helped, and people are less stressed because they're doing it in their living room or wherever. But I do think that I've had more discovery disputes this year than I normally have. And I've had more acrimony over lousy motions to set aside default when, they file them 2 weeks after the default is taken and they're still fighting about it. So there's a portion of the bar who has not been more cooperative and they stand out. And so I've had that. Anyway, and I would say on the steps to continue, I've been so grateful everyone's agreeing to continue everything. But at some point, we can't just keep continuing. We're going to have to resolve instead of continue. But so far, it's all worked out great. Anyone want to throw in anything else on the general topic of COVID during that? Okay, so let's jump to discovery. How has discovery been for you and civility in the last year? Let's go in the same order. Robin?
Thank you, Judge Fannin. It has been really interesting. The one thing that's been a challenge for me has been taking depositions. I like to really observe people. People have tells, and you miss that sort of thing on Zoom because you're only seeing normally from the neck up or the shoulders up. And I can tell if I'm in person, if somebody is a little anxious with the particular line of questioning that I have. It could be taps of fingers or feet or things that I can't see. And so I feel like I'm missing out there, particularly in depositions. As far as any other type of discovery, I think that it's worked out just fine, actually. And I like it. I feel that discovery disputes have been minimized for me, actually, because we know that if there is a problem, we do have to go into court. And now you can't just do a court call. And that is really interesting. I had a matter in front of another judge, Superior Court here in Contra, Costa County. And because we were on Zoom and the other counsel did not like the particular ruling, her sighs and eye rolls and all of that stuff were noticed by the judge and commented on. So, I mean, you really have to remain focused. And even if you are upset with a ruling or something like that, you cannot let that sort of thing come across on the Zoom screen, especially in front of a judge. So it's been very interesting, but I do miss in-person depositions. For me, that's been the hardest part of being on Zoom as opposed to being in person.
Phil? And also, if you could weigh in on your, if you served as a discovery facilitator in the last year, how that affected you.
I'd like to mention that all of us on this panel.
Phil, I need you, there we go.
Okay, can you hear me okay now?
Yes.
Okay, all of us on this panel serve as discovery facilitators. Not long ago, Larry and I gave a presentation with Judge Austin encouraging more people to sign up for that. And I could like to make another pitch for that. Recently, we received an email from the administrator saying, we're desperate. This is the third time we're trying to get somebody to take some of these cases. And she gave us a list of 8 cases. I triaged and I found 2 that had to do with depositions not being attended. And I figured that's an easy issue. So I took those and I immediately sent an email to the parties and I said, hey, let's just have a quick phone call and no written briefs. And we're going to do that tomorrow. I got an email this morning saying, could I at least just do a short brief? I said, no, we're going to just do a call. and let's just talk. I promise I won't decide anything. We'll just talk. But it's funny because tomorrow I'm going to be sitting in San Francisco as a Discovery pro tem judge in Discovery calendar. And I've been reviewing these massive pages. One party has done a motion against the other and seeking sanction, and the other party has brought another motion seeking sanctions. And honestly, I can't figure out what they're arguing about. There's so many pages to read. I didn't ever see anything. So I just did a tentative saying, the responses are sufficient from both sides. Request for sanctions is denied. Show up if you need to. Well, they both ordered court reporters, and they're going to be there tomorrow. And who knows what's going to happen. But yes, it's. I think people have too much time on their hands, and they're spending way too much time drafting discovery motions, and that part has become problematic during COVID.
Larry?
Well, I'm a facilitator also, and now I know it's clear Phil is cherry picking the cases, and that's why we get stuck with all the tough stuff. Good job. But anyway, no, I just wanted to tell. I will get back to that one second. I wanted to just tell. I do a lot of depositions, over Zoom, and I think they've for the most part gone really well. Sometimes there's like Robin said, you can't see what's going on in the room. So you might have a lawyer, coaching the witness going like this, and you can't see it, but the guy's looking up like this, and you have to say, what are you looking at? What are you laughing at? What's so funny? So that's been a little bit of a weirdness to it, but I have to say, it goes back to the civility thing. I think there's something about, when you're in people's homes, they might be in their living room, their dining room, they might have a home office or the bedroom or wherever. You're in their lives a little bit, and so maybe you're a little more careful. I have a case, a multi-party case going on with a lot of lawyers, and sometimes things get a little testy. But one of the lawyers, and this is the other thing, that people have kids at home because they haven't been at school and they haven't been at daycare and all this, and you have a lot of things to grapple with. I have a case where in almost every deposition, this attorney has a 4-year-old daughter, and she, the other day burst into the room, flips open the door, you hear it slam, and she demands that her father put a ponytail, and he's like, go to mommy, and he goes, no, I want you, I said. And it's a nice, I like that kind of thing, because everything gets just a little too heavy. So that's a little story. But as far as facilitating cases, it's kind of strange, because Judge Fannin says you see so many disagreeable people and all this, and then I get these cases, and I was having the opposite. Like why are you in front of a facilitator? You people are so, you're working everything out. I mean, we solve these things, and boy, nice talking to you, but it seems like you can work this out on your own. And then I never hear from them again, and the thing went away. So I just guess there's two sides of it, but you hate to think and hate to have too many cases where people are just being as difficult as they are. But I will say for a lot of lawyers, I will take my hat off to them, because they are working things out. And so it goes back a little bit, reflects on the ethics, in my opinion. Yeah.
Well, I have to say, of course, I get the cases where they didn't agree to the discovery facilitator, right? So that's what I'm seeing. But I do think there's been an uptick in that to some degree. And I would say not necessarily that, I don't know that this is why that's happening, but I do find that with discovery overall, everything is delayed, right? Your document demands are delayed. Your responses to subpoenas are delayed. You're getting your response to the IME is delayed. So everything is kind of kicked down the road. And I think people are getting very frustrated with the delay, not to mention the terrible delay at the courthouse. It's terrible. We are so backed up. And so I think there's this level of frustration that can come out in the discovery disputes. And for a lot of people, they serve the discovery in August, they meet and confer, they give extensions, then they go to the discovery facilitator, they don't get what they want. It's practically a year later that they're seeing me. So they're just ready to pull out their hair. But I would say to you, don't pull out your hair. Just because you're frustrated doesn't mean you are right. And I find that people, I read your emails to one another and I'm aghast. I read your letters to one another where you act, like you are the authority of everything. I see your insulting comments to opposing counsel. And I will tell you, there's that case that I think is in the materials, Ketchum, which says it well, that, civility is goes hand in hand with good lawyering, and you pay for bad lawyering. So when you insult the other side, you might be right, but I'm not going to give you sanctions if you're telling the other side that they're outrageous and stupid and how could they make this decision. And no, I'm not going to give you money if I can avoid it, or I'll give you the bare minimum. And you pay if on the other side, if I don't want to reward anyone who is rude and who puts down the opposing counsel. You can say things nicely. Please don't call an action by your opposing counsel outrageous, defies belief, that kind of comment. X that out. Do not bold and underline. Generally very bad. Maybe if it's critical in a contract dispute and you're bolding a phrase that I need to look at, but it shouldn't be in your discovery matters. And I get very frustrated when people file a discovery motion and then, I'm sorry, I'm just going on and on, but
I've got some questions for you. You've hit a nerve, Judge Fannin.
when people file a discovery motion and then they essentially win, the other side submits supplemental discovery responses. And yet they want to keep the motion on calendar and argue to me that the new discovery responses are inadequate. Well, I haven't been briefed on the new discovery responses. They came in the middle of the motion. Or they want to keep the motion on just because they want to fight for their $2,000 in fees. These are just some of my irritations. I think in general, you should, even though you're frustrated, I know the delay. If you get the discovery responses, let's move on. It's a new meet and confer process. I don't like having motions because you want to pound the other side to give you some attorney's fees. I think I find this same kind of negative behavior in motions to set aside defaults sometimes. I think we all know it's very easy to set aside a default, slight evidence. Why are you opposing a motion to set aside a default where the attorney says I screwed up? And please don't tell me that the attorney is an idiot for having made the mistake. It's kind of shocking to me. The civility matters. I remember the people who are rude. You don't want to stand out for being rude. You want to stand out for being kind and measured and just pointing out behavior, not, screaming that something is like the worst you've ever seen in your life. Okay, those are my thoughts.
So we've got that caused a number of questions to come up.
Okay.
Judge. So I guess the most appropriate one, given your comments just now, are when should attorneys respond to ad hominem comments from opposing counsel? And is it safe to assume that the judge will ask counsel to address the issue if the judge feels it is worth addressing?
I would say generally you don't need to respond. And I try to call it out in law and motion that the other side, I don't care for that kind of thing. You might just point out that, you take offense at the comments, but you're not going to, get in the gutter with them. I'd say that in a nicer way. But no, all of the judges dislike intensely people calling other people names, attacking their integrity, assuming that they don't, that the other side is nefarious. It's just, it's inappropriate. It's not read Ketchum. You will pay for that kind of attitude. So.
And so the audience knows we will be sending out a packet afterwards in that case, and the citation will be included. So you will get copies of that for attending the MCLE today. So next question, and I'm also a discovery facilitator, is are you seeing more cases come before you after the facilitators have decided? And are you finding that the facilitators are still doing, making the proper findings, or are you having to reverse more of the facilitator findings that are being brought to you? Is that what's driving this?
Sometimes, I also get them without having gone to the discovery facilitator where there's no response. And so that's part of it. But sometimes I do get them after the discovery facilitator. And sometimes the discovery facilitator has thrown up their hands and done the you win, you lose kind of thing. And then I have to kind of, break it down. But I appreciate every discovery facilitator who tries and throws their hat in that ring. God bless you, because that really helps us all get through this. And I do know a huge percentage of the cases resolve at that stage. And I do think I get the harder ones, right? Sometimes it's a closer call. And so I appreciate that. I'm not just going to say, well, whatever the discovery facilitator said. I mean, I do, take a look at it again. But if I think the discovery facilitator has made very good, reasoned decisions, and the other side just continues to be, sometimes I get the sense maybe it's for attorney's fees that they're going forward or things like that. That's not you don't want me thinking that. You want to resolve it. So I don't know. I can't get into everyone's head about why I see them, but there are a lot of discovery motions.
And then a third question for the whole panel. When you're suspecting that opposing counsel or someone else might be assisting the witness, have you ever required them to turn their camera and pan the room to see who else is in the room and or make sure they're all on camera?
Any of you?
Absolutely.
Well, no, I never made the requirement. I just speak up about it and say, if we were in my conference room, you wouldn't be doing that. So I don't know if you're doing it or not, but I suspect something's going on. So let's not have that. And then I honestly goes away. I think it may just be people aren't used to Zoom, and it's kind of a strange setup, and the intent isn't there to do anything out of line. It's just, you've got to kind of get with the program and remember that we're trying to replicate what goes on in my conference room and not, make your own video kind of thing. So.
And that's why Larry is a much nicer person than I am. And I'm sure a lot of people feel that.
Wasn't always the case. Wasn't always the case.
Have you had any issues like that in the court, Your Honor, with anyone trying to coach people or somebody seemingly off camera providing advice?
I haven't personally, no. And I welcome the attorneys being in the same room with their clients during settlement conferences, and so I don't mind. I'll just try to get out of the box if that's happening. But I haven't had that happen with motions or any kind of evidentiary hearings or anything like that yet.
All right, that's all of our questions so far.
So let's skip to mediations and settlement conferences during the last year in civility. Robin?
My experience with mediations and settlements conferences have actually been very positive. Like you just mentioned, Your Honor, my clients often want me to be in the same location that they are, unless my clients live in a different county, of course, and travel is an issue. We've been very comfortable the way that they have been structured, being in our own room, and my clients having the ability to speak with me freely. They also, in my cases, unfortunately, have a great comfort in not having to be in the same location as the other party. And I found that that has not only led to civility and a willingness to be open and listen to what the other side is discussing, but it has also led to more settlements, which has been a very pleasant turn of events. The one thing that has run through all of these issues, from discovery, the law in motion to settlement conferences and mediations, is when I am dealing with opposing counsel from Northern California, I have found that overall the experience has been very cooperative and civil. I've had a lot more cases recently with counsel and parties from Southern California. And that has been a completely different experience. And in a couple of those matters, downright hostile. And it was surprising to me. And then I had to remember I started practicing in Southern California, and how I was taught and my experiences being in court and dealing with opposing counsel. I've been up here so long that I'd almost forgotten how aggressive things can become when you're dealing with counsel from Southern California. And I'm not saying all counsel are like that, because they absolutely are not. But just on the cases that I've had, I have found that the aggression has been very, very high. And then you have the level of stress that you experience just from being on Zoom calls. There's nothing worse than staring at yourself when you're trying to deal with somebody else. Your face always comes up on the screen. I'm sick of looking at me constant. I don't look in the mirror that often, and I am always on screen. And then you're watching everybody else when I would rather be focusing on one specific person. And then dealing with hostilities from counsel who have no intention of being civil can be a challenge. And I have experienced that. And I really do see the difference in practice between Northern California and Southern California.
Now, is that with a mediator? It's still
Yes.
like that?
Yes. Yes. Mediators, judges, they just don't seem to care. And I have seen them get smacked down more than once, and they keep going, regardless of what the judge has to say or the mediator. And it at first it did surprise me that they weren't willing to listen, because they've been told this is not helping your case at all, taking this position, and they don't stop. And it's just been, I mean, why are you going to waste so much time and energy being negative and aggressive when you can be civil and get a lot more done, especially for your client? So that's been my experience.
Phil or Larry?
I've served a lot as a volunteer mediator, and I've participated in a lot of mediations, both as a mediator and as a participant in Zoom. And I should tell you that I believe that mediation is a time for people's hearts to change. It's not an intellectual experience, it's an emotional experience, and a positive emotional experience. What I'm getting at is there's an opportunity for a plaintiff's attorney, I believe, to influence the claims adjuster's heart if they will have a joint session, at least for a minute or two at the beginning, where the adjuster who's never seen this plaintiff can see them and hear them talk and get their story about how this has affected their life. And, part of the time as attorneys for insurance defense, I've done it for 37 years now, is we disagree with the claim representative sometimes on the value. We think it should be higher, but they don't feel that way sometimes. And so then we can have this opportunity for the plaintiff to actually influence them. I had a mediation last week where, without breaching the mediation privilege, where it turned out that the case settled for more money than we thought, because the claim rep went back and called the team manager after they had this experience and got more money. And I would have never thought that would have happened, but it was because they were all on the phone together, all on the Zoom call together, They saw and met the plaintiff, they heard the plaintiff's story, and it made a difference. So I love Zoom for mediations because we're including people that we never included before. And now with State Farm, the adjusters are all in either Arizona or Charlottesville, North Carolina, or Dallas, Texas. And we haven't been able to see them at conferences. And so now all of a sudden they're here in the room with us. We've had field representatives who have come in and have kind of sort of replaced them, but they're not the ones that have actually been dealing with the case day in and day out. So here, all of a sudden, the person that's been handling it is seeing it live, and it makes a big difference. So I'm a real proponent for Zoom mediations with a joint session at the beginning.
Larry?
Well, for me, I think there's a little bit of a difference between a Zoom mediation and a settlement conference. When I request a judicial settlement conference, or when the defense attorney and I jointly request one, it's kind of because we want the judge, the influence of the court to be imposed. And so I think settlement conferences with the judge on Zoom are fine. I don't think judicial settlement conferences that are sort of the settlement mentor type over Zoom have the same effect. And I guess I would rather have a settlement mentor at the courthouse, knowing that the judge is next door. If we can't have a settlement conference over Zoom with the judge, if that makes sense. I just think it's the aura of the court that sort of gets real for people. It has to get real at some point. So I would make that comment about that. But in terms of mediations, I think they're great over Zoom. I've had just really good experiences. Not that all cases settle, but I agree with Phil that it makes the joint session easier. It sets everybody at ease. Clients don't have to travel to San Francisco and have huge expectations that get shot down, and it's been a horrible day and all of that. A Zoom mediation is a very economical way to go. And you know, I like the fact that if we just disagree on the value of the case and everybody's there, but we just can't get to it over Zoom, we may get to it down the road, but we didn't, waste a whole bunch of time. And this whole idea of you got to have the adjuster there, I mean, that just falls flat to me most of the time. And so I think Zoom is a great way to do that. And I've had very good results over the last year in significant cases with Zoom mediation, and got more coming up this summer. So that's another thing that I hope carries forward, that we just develop sort of this culture of mediated settlements in Zoom and take advantage of it. Yeah.
A couple of things came up, Judge Fannin. First, for Robin, you can actually hide your self view, so you don't have to keep staring at yourself in Zoom. You're muted, Robin, but if you need help afterwards, we can show you how to hide your self view so you can stop looking at yourself, although we all enjoy looking at you. So you're muted, Robin. Next, as far as questions go, Judge Fannin, after COVID, do you think that the courts will be open to Zoom appearances for litigants who are required to personally attend settlement conferences to reduce costs and reduce traffic?
I don't know. I was thinking about that. I'm like everyone else. I was so pleasantly surprised with Zoom settlement conferences. I was a huge believer in you have to be here. Everyone's got to be here because it puts skin in the game and all that. And I have loved having the adjusters on Zoom because I get a lot more FaceTime with them now than I ever did. And a lot of times I see the parties more than I did. And so I have really enjoyed Zoom settlement conferences, and we have really had great success with them overall. Kind of going to Robin's point, though, there are people who we're never giving you more than 2 cents, or by God, we're breaking that policy. We're breaking that policy. And it's like, when I have those kind of people, I think I need them to be here, and I need their clients to be here. And I need people to understand this is the cash you could have today, or you really want to go to trial. So to the questioner's point, I think it's going to depend, and I'm going to need your input, you attorneys, on what kind of cases, and I'll have my own impression maybe from the discovery motions, but I think I'm willing to listen to the attorneys on is this a good Zoom case, that I don't need to have them come in to see the courthouse and get real. Are the attorneys, where are we? And so I would like to keep Zoom as well, but I do appreciate that there are a number of cases where really you got to show up and feel the heat at the courthouse. And so, I'm going to be listening, asking your advice on what you think about what kind of case it is.
So if there's a dispute, say Phil wants a Zoom mediation and Larry doesn't, how would you fall between that? Would it be the default is you're in person, or would it be more of your call as to which you order for the settlement conference?
I don't know. I mean, I think I just have to see. I have to see what the case is, and is it because, the client's 90 and lives in Eureka? I don't know. But I love the option. I love that we have the option. And if people don't have a good internet link, of course, that's something else. And I even found it works with Spanish speakers or other foreign speakers. It hasn't been as much of a burden as I thought it would be. I just think we have to play it by ear. But I love that we have a choice, at least with that.
And then one last question I've got here. Can the panel address how to deal with the situation where the court helps difficult opposing counsel and accommodates ongoing technical deficiencies, given that the rules of professional conduct require us to be competent in these areas? I don't know if you've run into that, where someone's having issues with their Zoom or computer and uses that as an excuse, or.
That's partly why I like court call, because eventually people can find the mute button. But sometimes on Zoom, it takes so long. So I don't want to have a Zoom CMC because it just takes too long, but I don't know about what you all think about it.
I would make a comment about the technology, just back on the subject of mediations, because there's a big difference in how mediators are able to use technology. Some of them are very, very good, and some of them just have not evolved into that, and it makes I've had Zoom disconnections and all kinds of stuff, or just I'm a mediator and I don't do Zoom. We'll do it over the phone. And okay, well, that's not the best. So my observation is that you want to look around and when you're selecting your mediator, be sure that they are going to deliver the kind of mediation that you want over Zoom.
Our facilitators attempted doing a discovery facilitator dispute over Zoom as opposed to a phone call. Since I know, Phil, you and Larry like to call the parties and get them together to discuss the case.
I'd be open to it. I haven't had anybody request that kind of thing yet. And if I'm at home and I want to do it early in the morning, maybe I don't want to, Zoom.
When I used to handle a lot of those cases, I used to get a lot of pro pers. And I just found that doing it over the phone was much easier than trying to set up Zoom conferences for that reason.
So we've sort of finished our topics, but let's go around and talk about what things besides Zoom mediations or maybe Zoom for discovery facilitator, what things we want to have continue from this year. Like, what do you think about court trials on Zoom?
I'll speak up on that. I haven't done one, but I'd really like to do one. And I think maybe it's just me, but I'm very into finding economies in this process that we go through. And I see a ton of wasted money and wasted time. And I am very much in favor of trying some new things. And I would welcome, I mean, there have been Zoom jury trials across the state. And everybody has an opinion about them. You know, from the defense side, some like it and some don't. From the plaintiff's side, a lot of plaintiffs' lawyers were late to come around to it, but I think the results have been pretty good. So I'm kind of anxious to do it.
A Zoom jury trial?
No.
Oh, okay. Okay. A Zoom court trial. Okay.
A Zoom court trial. Yes.
All right. What do you think, Robin or Phil?
I have one coming up June 1st. It is a bench trial in San Francisco, and I am very excited about that. I'm very grateful it's not a jury trial because I think that would be very unwieldy over Zoom. I had a couple of others that were supposed to come up, and of course, we had very effective judges handling mandatory settlement conferences, so we didn't get there. But I have a feeling that this one is going to go. So I'm really looking forward to the trial. And actually, I'm very happy that I will not have to be driving into San Francisco for a week. That I was not looking forward to. So I think that alone takes away a tremendous amount of stress, not only for the lawyer, but for the client as well. And as Larry mentioned, financially, it just saves so much time and money for the client. So I think that it's a real positive, and I hope the experience will be positive. But I don't know about having a jury trial that way. That would make me quite nervous, to tell you the truth. And since you put your thumb down, Your Honor, I'm going to take that as something I don't need to be trying anytime soon. So.
At least not with me. Phil?
With respect to court trials, normally the insurance companies prefer to have a jury trial. And so that's really what it comes down to. And they'd rather not have it by Zoom. I was the first lawyer to try a case in San Francisco in Zoom. I tried it last November, a personal injury action. And we had one witness. Everything was live. My client actually was 4 months pregnant and she was in the courtroom. It was very scary. Everybody had masks. They're all spread out through the courtroom. Very difficult to communicate with a mask on and use all the things we like to do with body language and smiles and frowns, and it just didn't work. So we had one witness, a key witness by Zoom that testified during the trial. And the jury hardly could see the person, and they didn't buy, I don't think, what we were trying to get across. And we didn't lose the case, but we came out in the middle between the offers and the demands. And I feel like part of it was because we didn't have that key witness who was the employer of the plaintiff, who was going to say the guy was fine, he was working fine, and he was claiming he couldn't work. So that was kind of a lesson to me that you need to have key witnesses in the courtroom live to get their influence across.
Phil, was that more because of the technology though? Because the Zoom wasn't working as well and the jury couldn't see? Do you think if you'd had a clear picture, it would have been better? I
think it could have been better. There were only 3 jurors in the jury box. The rest of them were all out in the seats, way to the back of the back. And we had just this one camera, one screen that was only, 36 inches or whatever. And it just wasn't big enough.
Well, I would say I'm anxious to keep doing, if people want, I'm open to doing Zoom court trials, provided the documents arrive first, provided people know how to share a screen, provided it's not going to be a big case about rebuttal documents, because how do I get them, and all that. You cannot be relying on the staff to do that kind of thing. And I would also say it would have to be the kind of case where there really isn't a sense that the witness is going to be kind of in cahoots with somebody. It has to be, you know what I'm talking about. I don't want it to be a case where someone's thinking that the other side's cheating, they're getting fed the answers, or if that's going to be possibly an issue, of course, that's not going to be good for a court trial on Zoom. And so again, just for who's ever out there, I'm open if you all agree to do a court trial on Zoom. I would consider that, but I think we'd have to have a stipulation. I don't think it could be something where I would say, I'm demanding you go to a court trial on Zoom. And I do think in the future, we may have more what Phil had, where we have jury trials and the faraway witness is on Zoom, on a big screen. But I hear, Phil, that it would have to be like the jury, maybe they're masked, but they're all in the jury box and they have a view and they can hear. And right now, we don't have that technology in my courtroom. I don't have a projector system. I don't have, we're still in the dark ages. I'm in my chambers because this doesn't work in the courtroom. So, I don't know how that's going to work. And we can't have more than one Zoom going at the same time in the courtroom. There's not enough bandwidth. So I can't really do a Zoom in person in person, and then we go to Zoom unless everybody, I've tried that, and then people have to go to their cars and they're on their cell phone. So, we're not there yet with our technology, but I think that'll be the future.
But it
Have you
might
done
be.
a Zoom trial yet, Judge Fannin?
I've had little court trials or, little hearings, but it has to be people that are comfortable with the technology. Some people just aren't.
Judge Austin
I would feel
talked about doing one, and he said he actually prefers it because of his ability to better see the witnesses. And his preference going forward would be to do more bench trials over Zoom than in person. I don't know if you have a feeling one way or another about that.
Again, I think it's going to depend on the case. I like seeing the person. Again, if anyone is thinking that the witness is cheating, then we can't do it on Zoom. And if it's a big document case, maybe not, because I know in family law, they're doing these things where everyone sends in, like some kind of packet of documents and everyone can get to them. And I don't want to be getting to them myself. I want you to bring it up. And I need to have a document that's filed, So I don't know how that'll work. So it's just going to depend on the case, but for sure I think there will be good cases. And I want to also do Zoom oral argument. I haven't, because my fantastic clerk, Benna, retired and she didn't want to do Zoom. And we're getting new Zoom links or something soon from the Judicial Council. And, shock, that's been delayed. And it's going to be delayed again. So I haven't put up the Zoom link because it's going to switch pretty soon here. But I think in the future, if people want to argue, if there's a stipulation to argue on Zoom, I could see doing that because it's nice to see both parties when they're arguing. But I think the default is not, it has to be a stipulation, Anyway.
I was going to add that one of the things I hope going forward is that we do make better use of the Zoom court trial. And in kind of going along with that, I think it makes a lot of sense to have a sort of a hybrid situation where if you have a lot of medical testimony, let's say, let's record all of that, the direct and the cross and the redirect. Let's record all of that part. And, then you can play it during your Zoom trial. You don't have to have, an orthopedic surgeon, sitting by in San Francisco on a Zoom. You can have all of that done in advance. And if you have, documents or records that need to be admitted, then they can be all submitted in advance. Everybody looking at the same thing, the same numbers. It just seems like a way to streamline things. I'd encourage that just even for regular trials, just to be able to move the trial along efficiently and smoothly. I mean, not waiting for witnesses or calling them out of order or things like that. It could really help.
Going back to the civility piece, I think Zoom trials, Zoom court trials and Zoom arguments does lend itself more to civility, because you don't get the same tension on the screen as you do live. And I think people are more relaxed, as I said, in their homes. And to Robin's point, they can see themselves like with their veins coming out. It makes people, kind of chill out a little. And so I think there's many situations where it diffuses the tension. But and I think that makes people behave better.
Agreed.
Agreed.
And does the panel have any advice for how to deal with witnesses who are only on a cell phone when they have to go and do Zoom activities for the court and discovery?
Don't be in your car on the Zoom. I don't like that.
Don't be in a BART station.
Right.
And then Judge Fannin, do you think we're going to see some revisions to the local rules to incorporate more Zoom options or stipulations, things like that, that address some of the questions that you've brought up going forward?
I think we'll have to. And I think you all should be very involved in coming up with what we say. I wanted you to know that very soon we'll probably go back to the courtroom being open and people coming in for CMCs, which, as I said, that kind of saddens me because it's not efficient and I'm going to do a hybrid, but it'll be nice to see people. But what I think that means is, well, I wanted you to know that I don't think it can happen right away necessarily. It's not like we can say tomorrow, because we have not had in civil or in probate, except I think for Judge George, or in family law, any deputies for over a year, except in the rare instances where we get, an unlawful detainer trial or where we have hearings. So the sheriff needs to staff us up. And so we have to work through that, and of course, notifying the bar when we're going to start doing that. But we'll probably go back to the old, you come in and some people are on the court call for CMCs and some people are in person. But I can't really do a hybrid in person and Zoom. As I said, it doesn't work.
All right, I don't know if I don't have any other questions that have come in for the panel. And I'm not sure Anne's still here, what time the panel is supposed to end. Hi, Anne.
I am always here, David. I think we're good. It was wonderful. If there's nothing else and no more questions, the panelists have done their final words.
I would just say very briefly that civility is a value, and we need to remember that and not tolerate aggressive communication or behavior from opposing counsel outside of the court and in the court. You need to be able to read your audience, especially when you're in court. I mean, if you have an opposing counsel, like I've had numerous times, that's going to get on a Zoom call in court and misbehave, act uncivilly, you don't have to do anything. The judge will take care of that for you. And I have found that to happen over and over again. When you're a younger attorney, you always feel you need to say something, but you don't. It's very clear when somebody has crossed the line, and the court is very good at letting those attorneys know when they've gone too far and that they don't appreciate that behavior. So just please remember, we need to value civility. I think we do an excellent job of that in Contra Costa County and in our surrounding counties. And that has made this whole Zoom civility issue a positive experience for me.
We do have one final question for Judge Fannin that just came in. And that is, have you ever imposed sanctions for incivility under the local rules?
I've found a way to impose sanctions. I'm not sure, I can't remember how, but I think, it's really offensive to me when attorneys are rude to one another. It's just unprofessional, and there's no cause for it. Even if the attorney doesn't exactly know how to do something, it doesn't matter. There's just no reason to be rude. So I don't know that I found that local rule, but I've found a way to make my point, even if it's a small point. To me, it doesn't have to be a big number. That's not the issue. It's that I don't care who you are, you should not insult or demean or disparage your opposing counsel. I just cannot tolerate it. Phil, I think you were trying to say something.
Including remark, if you can hear me. I received a text from a relative today who several months ago was out kayaking in Hawaii in the ocean with his wife. He jumped in because he wanted to watch the whales, but it wasn't a whale, it was a tiger shark. And he was in eye contact with this shark, and he was able to jump out of the water into the kayak just in time when the shark was going to get him. He didn't get hurt, but he had a near-death experience. We've all had a near-death experience, and we have changed because of it. And I hope that that change will make a difference. And this text from my relative was, the lesson I learned was to be forgiving and to forgive. And I think that's the message we need to have as lawyers. I mean, we get so caught up in it, but give them a break. Let them give you a break, and let's try to get the job done and get to the point and get rid of the emotion and the anger. So that's my 2 cents.
And I would like to say, I love Contra Costa attorneys. By and large, everyone, it's a pleasure to be in the civil assignment. The bar is great. Generally, people get along. People are interesting and funny, and it's a pleasure to work with all of you. And so, as I said before, the individuals who are rude, who don't value civility, they stand out, and we don't forget. We have long memories on that. Even though everyone has a bad day, don't get me wrong. If just because, you said something intemperate one time doesn't mean we're like, oh God, that attorney. No, everyone has a bad day. But when people keep crossing the line, we remember.
All right, well, thank you so much, Judge Fannin, for your time and insights today. And thank you, Robin and Phil and Larry for being here with us, and David for keeping us all on track. And I wish everybody a great weekend, and we'll see everybody soon again. Thank you very much.
Thank you.
Yeah.